SPEDTex, Special Education Information Center, shares Know Your Rights, a brief guide to the Notice of Procedural Safeguards. What is the Notice of Procedural Safeguards? This document explains parents' rights and responsibilities under the Individuals with Disabilities Education Act, IDEA. This guide provides a brief overview of each section of the procedural safeguards. Please view the full version of this document located in Parent Resources at www.spedtex.org. When should I receive a copy of the procedural safeguards? IDEA requires that school districts and charter schools provide the procedural safeguards to parents once a year and on the following occasions: upon initial referral or your request for an evaluation, first occurrence of filing a due process hearing complaint or special education complaint during a school year, disciplinary change of placement, request by a parent. Language requirements. Provide copy in parent's native language or other mode of communication unless it is clearly not feasible to do so. If mode of communication is not a written language, school must translate the notice orally or by other means so that it is understood by the parent. SPEDTex has translated the procedural safeguards and ART guide into several languages. Both of these documents are available for download from Parent Resources at www.spedtex.org. Foster Parent as Parent, page 1 of Procedural Safeguards. A foster parent for a child with a disability may serve as the parent if they agree to participate in making special education decisions, complete the required training before the child's next ART meeting, but not later than 90 days after they begin acting as the parent. Surrogate Parent, page 2 of the Procedural Safeguards. If, after reasonable efforts, the school cannot identify or find the parent of the child, or the foster parent is unwilling or unable to serve as a parent, or the child does not reside in a foster home setting, or the child is a ward of the state or an unaccompanied homeless youth, the school must appoint a surrogate parent to act in place of the child's parent unless the child is a ward of the state and a court has appointed a surrogate parent. Surrogate parents must complete the training program before the child's next ART meeting, but not later than 90 days after the initial appointment as a surrogate parent. Child Find, page 2 of Procedural Safeguards. Child Find. All children with disabilities living in the state who need special education services must be identified, located, evaluated. This includes children with disabilities attending private schools. Prior written notice, page 2 of Procedural Safeguards. The public school must provide you with written information, prior written notice, before it proposes or refuses to start or change the identification, evaluation, educational placement, or special education services provided to your child. The school must provide you with the prior written notice, even if you agree to the change or requested the change. The school must give you prior written notice at least 5 school days before it proposes or refuses the action unless you agree to a shorter time frame. Parental Consent, page 3 of Procedural Safeguards. Informed consent means that you have been given all the information related to what the school is asking permission to do. Voluntary. Granting of your consent is voluntary and can be revoked at any time, but you must do so in writing. Revoking consent is not retroactive. Parental consent is required before conducting an initial evaluation for special education, to provide special education services for your child for the first time, to reevaluate your child unless the school can demonstrate that it took reasonable measures to obtain your consent and you failed to respond. Independent Education Evaluation, IEE, page 4 of the Procedural Safeguards. If you disagree with an evaluation provided by your child's school, you have the right to request that your child be evaluated at the school district's expense by someone who does not work for the school. When you ask for an IEE, the school must give you information about its evaluation criteria and where to get an IEE. Discipline Procedures, pages 5 through 8 of Procedural Safeguards. If your child violates the school's code of conduct, the school must follow certain procedures if it removes your child from their current placement and that removal constitutes a change of placement. Your child can be suspended for up to 10 days in the school year without creating a change of placement. If your child is suspended for more than 10 days, then a change of placement has occurred and an admission, review, dismissal, ARD, meeting must be held to conduct a manifestation determination review, MDR. Manifestation Determination Art Committee will review all relevant information, determine if the misconduct is a manifestation of the child's disability or the result of the school not implementing the student's individualized education plan. Is the misconduct a manifestation of the child's disability? If yes, and if there is no behavior intervention plan, a functional behavior assessment will be conducted. Then a BIP, behavior intervention plan, will be implemented. If there is already a behavior intervention plan or BIP, the committee will review and modify the BIP. If the answer to this question is no, your child can be disciplined in the same manner and for the same duration as non-disabled children. Your child must continue to receive free, appropriate public education. Discipline Procedures, page 6 of Procedural Safeguards. If your child's conduct was the direct result of the school's failure to implement your child's IEP, the school must take immediate steps to remedy those deficiencies. Your child must be returned to the placement from which they were removed unless the misconduct involves a weapon, illegal drugs, or serious bodily injury to another person. Discipline Procedures, page 7 of Procedural Safeguards. There are protections for your child if they have not yet been determined eligible for special education if the school had knowledge that your child has a disability before the behavior that resulted in disciplinary action. Education Records, page 8 of Procedural Safeguards. Upon your request to review your child's records, the school must make them available to you without unnecessary delay and before any ARD meeting, due process hearing, or resolution session, and no later than 45 calendar days after the date of your request. Is there a fee? If you request copies of your child's records, the school may charge you a fee for copying if the fee does not keep you from being able to inspect and review the records. Your consent or the consent of the adult child must be obtained before education records can be released to people or organizations outside of the Texas public school system. Voluntary private school placement by parents, page 10 of Procedural Safeguards. Parents have the right to voluntarily place their child in a private school, but federal regulations do not require a public school to pay for the cost of education, including special education and related services for your child with a disability at a private school or facility if the public school made free appropriate public education, FAPE, available to your child. Private school placements when FAPE is at issue. page 10 of Procedural Safeguards. If your public school was providing special education and related services to your child and you chose to place your child in a private school without the consent of or referral by the public school, a court or due process hearing officer may require the public school to reimburse you for the cost of enrollment if the court or hearing officer finds that the public school had not provided FAPE in a timely manner before you enrolled your child in the private school. Transfer of parental rights, page 11 of Procedural Safeguards. All parental rights under federal regulations transfer to your child when the child reaches the age of 18 in Texas. At the age of 18, your child has the right to make their own educational decisions. The school must still provide you with notices of ARD committee meetings and prior written notices, but you may not attend the ARD meeting unless the adult child specifically invites you to the meeting or the adult child gives you that right in a supported decision-making agreement. On or before the student's 17th birthday, the school must provide you with written notice about the transfer of parental rights to your adult child unless you obtain guardianship or the student signs a valid power of attorney or a supported decision-making agreement. Resolving disagreements, page 12 of Procedural Safeguards. You are strongly encouraged to work with school personnel to resolve differences as they occur. You may ask the school about what dispute resolution options it offers for parents. Texas Education Agency's options for resolving special education disagreements, pages 12 through 14 of Procedural Safeguards. State IEP facilitation. The disagreement must relate to an ARD committee meeting where mutual agreement was not reached on at least one of the required areas of the IEP and the ARD committee agreed to recess and reconvene. The goal of mediation is to assist the parent and the school in reaching agreement. Special education complaints must be in writing and describe the special education violation, facts on which the complaint is based, parent signature, and contact information. A parent can also request a due process hearing from TEA on any matter relating to the identification, evaluation, or educational placement of their child or the provision of FAPE to their child. Got questions? You are welcome to contact us at 1-855-773-3839. We are SPEDTex, the Special Education Information Center. You can also contact us via email or web chat at www.spedtex.org. We are a collaborative project between Texas Education Agency and Region 10 Education Service Center. Thank you.